By watching our videos, you agree and understand that the information provided by our experts and attorneys, including comments and replies from users, is not legal advice. So, use of information is at your own risk. Folks, welcome back to Immigration and Jobs Talk Show. I am Nipasa Pradhan, and before I start off, I would just like to say thank you to my colleague and host Rajni Barara. That was a very, very interesting show indeed with astrology expert Deepika. Thank you so much. And welcome again. This is going to be another very interesting session today because we are going to have another familiar face, though after a while. Somehow I felt like it was very, very long, this gap. But then, yes, please help me welcome back Chand Parvathaneni to Immigration and Jobs Talk Show. How are you doing, Chand?
Hello, Nipasa. Thank you so much, and hope you're having a great day. And then hopefully we'll have another very informational session today.
Absolutely, I am, and I am looking forward for the whole session, which is going to be for an hour or so. So wherever you have joined us from, friends, whether on Facebook, LinkedIn, YouTube, Twitter, don't forget to subscribe to our channel also, and be with us because this is the perfect stop for you, to know everything about immigration and jobs. So yes, today's topic we are going to discuss with Chand is displayed on the screen, and that is, H-1B RFE trends at the common ones and consular process versus change of status for H-1B. We are going to cover everything about it. I have some questions, and wherever you are, if you have any questions also, don't forget to leave your questions in the comments. Also, at the same time, if you could tell us where you are joining from with the city and state, it would be very, very helpful for us to get your answers more precise to you. So, right, Chand? Doesn't it help?
That's correct. Mhm.
Yes, right. So, Chand, what can folks out there expect from us in today's session?
Sure. So, as we all know, the lottery was over last week, and the petitioners, the companies have started filing. A lot of companies have already started filing, and things are moving quick. There is a deadline. The deadline is still a couple of months away. June 30th is the deadline. And again, most of the filings do happen in April and May. A lot of people don't want to wait until the last minute.
Mhm.
And two things will happen. One, the case will get approved, the H-1B case, or USCIS might issue an RFE and request for more evidence. Typically, there is no direct denial. Most of the time,
Mhm.
USCIS does give an opportunity back, and they will request for more evidence if they have a problem. So the goal again is to get a direct approval. But if you don't get a direct approval, what's going to happen is you are going to get an RFE, a request for evidence. And it is very important that people know what kind of RFEs are issued. So that way people are cautious, and at least a few things you can try to include them upfront in your petition, avoid the RFE. That being said, sometimes even if you do everything right, even if you include everything, sometimes because of what the USCIS officer finds in their system or during the background check, sometimes it is very common that they issue an RFE. Maybe the RFE is something simple, maybe something about somebody's status in the past, maybe something
Mhm.
about somebody's education in the past, maybe something about the company. So various things. But again, RFE does not mean anything bad, does not mean your case is getting denied. But again, it adds to the timeline. The case will get a little bit delayed, and the
Mhm.
goal is to educate what kind of RFEs you're going to see today, see nowadays. And also, there is a lot of interest in consular processing. So when somebody is in US and an H-1B is getting filed, typically people do it as a change of status, and some people do it as consular. It's a recent trend, but it is picking up. And since a lot of people have a lot of concern as well as confusion over these two H-1B filings, H-1B filing with change of status or H-1B filing with consular process. So we'll also try to use this session today to look at the differences between these two and see if anything is better than the other one, and any questions surrounding the RFEs and the ongoing H-1B filings that are being done subsequent to the H-1B lottery.
For sure, for sure. We will cover each one of them possibly. And for folks out there who have joined us for the first time, maybe, and who have seen Chand for the first time. He is attorney Chand Parvathaneni from SPB Law Firm from Dallas, Texas, and has been practicing immigration law for quite some time now. And Chand, maybe you would like to tell a few more lines about yourself before we move ahead and delve into the questions about the topic from the topic.
Sure. So I'm practicing as an immigration attorney since 2011. So it's almost close to 13 years that I've been practicing in Dallas area, and I've been in Dallas area since 2000. It's almost 23, 24 years that I've been in Dallas area, and been working with hundreds and hundreds of IT companies, software services companies, and as a part of my career in immigration law, I have helped in filings, a couple of thousands of filings, at least 15,000 or more H-1B filings in my entire career. And what that means is we have extensive experience, not only experience, but also the kind of data that we have. We kind of see
Mhm.
the trends, the past trends, the recent trends, what we can expect in the future because of the kind of volume of cases that we work with. And I mean, most of our filings are in IT related professions. IT is a big, it's a profession that's in great demand, and the pay is high. So there is a lot of demand. There's a lot of talent crunch in the United States. So we primarily work on the IT filings, and most of the data that I have, most of our filings are typically IT related filings. And based on our experience today, I can give you some trends and what could be expected for your own H-1B filings.
For sure. I'm already looking forward. And Chand, we have people who have joined us also on YouTube already and Facebook also. So wherever you've joined us from, don't forget to ask your questions, drop your questions in the comments, all right? And I have this first question for you, Chand, and that is, how can one handle an RFE for H-1B or OPT if attending a college known for higher RFE rates, especially when living off campus, how to maintain status to avoid potential issues?
Sure. So there are two things that are happening here. So one, when somebody is on an F1 status and they're applying for their OPT, they're applying an I-765 for their own OPT. The
Yeah.
recent trend is we have started seeing a spurt in the RFEs. Previously, the 765, the OPT RFEs for people who are applying for I-765, the OPT EAD card, it was very rare. Recent trend is we are seeing a lot of these RFEs. And not only that, the other scenario is when somebody's H-1B gets filed. So when somebody who's on a student status, who's on OPT, their H-1B is filed, we're also seeing an increase in the number of RFEs when somebody is on OPT status. And if you look at what is happening is USCIS is trying to ensure that somebody is maintaining their valid status. So if somebody's on F1, somebody's on OPT, they're trying to make sure that somebody is having a legitimate job, legitimate OPT job. They're working in the right field, and they have done everything they're supposed to do in F1 status. And recent trend is there have been some companies who have created fraudulent offers. So there was a recent case where this company was issuing fake offer letters. There was not really an offer. They were issuing fake offer letters for these OPT students. They were charging money. And we also had a few cases a couple of years back. If you Google Integra, you will see what I'm talking about. So again, this company, again, there was no real job offer. They were, I think, charging some money from these OPT students. They were trying to create a job offer, trying to make it look like they were doing something on OPT. A lot of fraud started happening, and USCIS started uncovering this fraud. So USCIS, on their side, from their perspective, they're being cautious, and they have trends. They have a lot of data. They have very, very good computer systems. They can easily find fraud. So based on that, what is happening is they are kind of seeing fraud from some universities. Maybe some universities which are giving a lot of CPTs, which have CPT programs. Maybe some universities have a lot of coursework that is designed to be completed in maybe like in 1 or 2 weeks, and the other entire rest of the semester, the student doesn't even need to live on campus. So what we see is we are definitely seeing a trend in increase of OPT RFEs, and also some universities. those universities where their program is not spread out through the entire semester, where people tend to not stay on campus or close to campus, but live in a different city and probably come over only for their classes on the weekends. So some universities do have those programs where the classes are all fitting in one weekend or 1 week of an entire semester and so on. So those kind of universities, we definitely see a higher chance of an RFE. That being said, an RFE does not mean you will get a denial. RFE means that we do have the burden to provide all those documents that USCIS is asking. And even though the RFEs are increasing, majority of these RFEs will get approved because majority of the people are always trying to follow the rules. But because fraud has been detected in the past and there are some kind of patterns, USCIS typically tries to target such patterns and go after those cases where they think that there is more chance of fraud.
Right. So basically, an RFE is request for evidence, not a denial, friends. You do not have to worry. All you have to do is collect more evidence and provide what is required, what they have requested you to provide them. All right. So we have, Chaitanya on YouTube who has joined our show. Hi, Chaitanya. I hope you're doing well. Thank you for joining us. And Chaitanya is asking, do Canadian passport holders born in India and currently residing in Canada need to attend consulate interview for H-1B stamping?
So if somebody is looking for H-1B stamping and somebody has a Canadian passport, they still need to go and through the H-1B stamping process. However, there are some visa categories such as TN. So somebody has a Canadian passport because you don't really have to work on H-1B. You can even work on TN visa. A lot of Canadian passport holders, even though they're born in India, they can still utilize the TN visa, for example. So if you're utilizing TN visa, then you can come and work on TN visa in the United States. And for TN visas, you don't have to go for stamping. There is a different process. You just go to the CBP, the port of entry, and you simply show your credentials to the CBP officer. And without a visa, you can come into US. Similarly, there are a couple of visa categories. There is J1, for example, exchange students. There are some visa categories where if somebody has a Canadian passport, they don't really have to go for visa stamping. But for H-1B, they still do need to go and go for visa stamping. And again, some people might qualify for Dropbox. If some people qualify for Dropbox, the interview is waived. But if not, they still have to get the visa stamp, the H-1B visa stamp, and then come to United States.
All right. So, Chaitanya, I hope that was helpful for you. And thank you, Chand, for taking that up. Well, Chaitanya, if you need more clarifications or anything, we are still here. Keep commenting your questions and we will take them up. All right. Moving on, Chand, I also wanted if you could actually outline, some of the common RFE questions. For example, are you attending on your on or off campus classes, et cetera, et cetera. So tell us some of the common RFE questions out there.
Sure. So in terms of the common RFEs for H-1B, the H-1B RFEs can be categorized into some very high-level buckets. The first one is typically if somebody is on student status, F1, the most common RFE is regarding maintenance of status. So it's a simple RFE. All they say is USCIS asks about the F1 status. So typically questions like, prove that you attended full course of study. So as a student, you're supposed to attend full course of study. And what that means is proving that you attended classes, proving that you passed all the classes, you're graduating, and you paid the tuition, and you ensure that you maintain your F1 status. That is full course of study. That is a very common RFE. The other kind of RFEs are regarding the OPT, because during OPT, people are supposed to work. They cannot have unemployment that exceeds the allowed unemployment. So typically for OPT, the kind of RFEs that we see are, does your job correlate with your degree? Very important question that they ask. They also ask about your employment history because they want to know how many days of unemployment you had. If people have more unemployment than allowed, there's a problem. So that's a very common RFE. And the third kind of RFE we see for students is CPT. If somebody has taken CPT, if somebody has taken and undergone a CPT program, more than likely they will be issued an RFE where they will be asked to prove that they attended all classes, they traveled to the school, they have travel receipts, and not only that, we also need to prove that CPT is integral to the program. So not anybody can take a CPT. The CPT has to be integral to the course of their study, and the university should require it. So more than likely, they will see something around these lines. And for somebody that is not an F1, the general H-1B. So during
Mhm.
CAP season, the next most common RFE that we see is beneficiaries qualifications. In the H-1B world, the degree has to be a direct match to the occupation. So what that means is, if somebody is going to work as a software developer, the industry standard requires a specific degree, which is computer science, information technology, or something close.
Mhm.
And if somebody does not have a US degree in these fields, or if somebody does not have a relevant degree, so maybe they have a mechanical degree or a civil degree, for example, civil engineering. And the most common RFE that we see for those folks is prove that you have an US equivalent degree in the very specific field, in the specialty occupation. So that is a very common RFE. Again, it is not very difficult. We either get an evaluation done, educational evaluation done if they have a foreign degree, or if they don't have the right degree but they have the work experience, we combine the experience, we combine the degree, we do an academic and work experience evaluation. So that's another very common RFE question that gets asked. Prove that the beneficiary is qualified, even though they don't have the right degree. That's one common thing. And another uncommon thing that we get, not on a very large scale, but we see it time to time, is regarding the company. So they will talk about the company and say they're not able to do a vibe check. And they will ask us to provide things like the company lease document, the company invoices, the company bank statements, the company tax return, uh, things to show that the company is a legitimate company. So this happens time to time. And again, it's not a very hard RFE to tackle, but again, that is something what the company will have to provide to prove that they're a legitimate company. And so high level maintenance of status, beneficiary qualifications, I would say, are probably the majority chunk of all the RFEs that we get. And there are other simple RFEs. I mean, not simple, but the RFEs that do come up, I mean, time to time. A specialty occupation RFE is one thing. They will ask us to prove that the occupation is really a specialty occupation. It's a little bit complex RFE, but again, the volume is not too high. And sometimes they also talk about the wage levels, the salary. If the salary is too low, the wage level
Mm.
is too low. We occasionally see an RFE that talks about the low wage and asks us to justify that it is a specialized occupation. That's another common RFE. And another common RFE that we see, not a common RFE that, but it's an RFE that we see time to time, is regarding the LCA, the ONET codes, and the relevance of the ONET codes. So again, for all the folks out there, the ONET code is very important, and everybody should get a copy of their LCA. By law, the USCIS current regulations, they require that the LCA copy be provided to the employee. The company has to provide the LCA copy. They don't have a choice. So it is extremely important that everybody gets a copy of their LCA from their employer and see what their ONET code is, what their salary is, and so on, because that will tell somebody where exactly they're supposed to work, what exactly is their salary, what exactly is their ONET code. So overall, these I would characterize as the most common RFEs that one could expect, either about the beneficiary qualifications, either about the company, or either about their status. So most of the RFEs will be around circling around these areas, and
Mhm.
majority of the RFEs are very easy to tackle. It is just that you have to gather all the documents, be very diligent, and adhere to the deadline. The deadline is super important. You cannot miss the deadline, and ensure that you collect all the documents. The notice from USCIS, most of the time it will be very clear. The USCIS doesn't confuse us. They will clearly list out the list of documents that they want. Just gather those documents, try to provide it on time. And normally, if you're not able to provide each and every document, most of the time it should still be okay, because always there are alternatives, and that is what typically the companies work with attorneys on. In case you don't have the exact set of documents that USCIS is asking, sometimes there might be some alternatives. However, the thing is that you do prove the legal aspect that they are asking, and do answer within the deadline time. Doing so, most of the cases should get approved.
Okay. Thank you so much, Chand, for highlighting what to keep in mind while, dealing with an RFE. And also, Chand, we have someone in the audience, Akhil Verma, asking, there are two parts to this, so I'll take one at a time. Today, I have seen on social media that US Customs and Border Protection has visited the candidate's LinkedIn page. His H1 was picked this year. So is this common? And the second bit is,
Uh,
I mean, are they verifying it before processing? How should we consider it? Interesting. Thank you,
sure.
Akhil, for the
And
questions.
again, yeah, I mean, again, this is a very good question. And again, the social media, it gets checked when somebody's in US. It could get checked, and it could also get checked when you go for visa stamping, interview stamping after the process. So these are all possibilities. And normally, again, what happens is everybody has a different trigger, and everybody has different kind of reasons why something got triggered. And if somebody is on F1 status or OPT status, they're currently working in the country, and it does not even matter that the H-1B got picked up in the lottery or not picked up in the lottery, because if somebody is in US and there is some trigger, for example, somebody applied for OPT and they're seeing some kind of an employer on their I-20, and that employer has some problems, for example, that could trigger some background check. So, for example, there were some companies that ran into issue because they were misusing the OPT program. And if somebody is working for that company and their I-20 reflects that, and USCIS or Department of Homeland Security, they have access to that information, and something triggers something. So, for example, this guy, because he's working for some company or because somebody complained that he's doing some illegal, unauthorized employment, somebody complained against him. We don't know. So, all these things could trigger something. And if there is some kind of a background check happening, it could trigger some research. We have also seen when somebody is not even picked up in the lottery and they're on OPT status. I have seen cases where Department of Homeland Security got involved. They did a site visit, not during H1, but during even OPT. So these kind of things are possible. And what that means is if somebody is in US, they have to ensure that they are in 100% compliance with all the laws. What that means is if somebody is in US, they cannot work without authorization. If somebody is on a non-immigrant visa, somebody cannot do a job that is not authorized. So basically, if somebody is a student, they cannot go and work at a restaurant. They cannot go and work at some grocery store. Somebody cannot go and drive Uber. So there are restrictions on what you can do as a non-immigrant. And if there is something that triggers or something that is there in their background, things could be triggered. And maybe the CBP officer is not only looking at their LinkedIn, they're also trying to find their Facebook. And they're trying to do various other things. So these things are possible. Again, I would not say they're done on a large scale. But that being said, everybody has some kind of a trigger. And if something in their background triggers or there is some kind of a factor, there is always a possibility. And not only that, remember that when you do your DS 160, apply for a visa, you're supposed to disclose your social handles, and you're supposed to disclose it to them in the DS 160. So the checks are possible. And not only that, when somebody is actually entering the country in the airplane, so they get out of the flight, they go through the CBP inspection. At the CBP inspection, the phones can be taken from these folks, and the CBP officer can actually inspect the device. He can actually look at the contents of the device. So, and what that means is you have to ensure that whatever you put on the DS 160 is 100% accurate. Whatever the officer asks you in the CBP interview is 100% accurate. Always be prepared. So things on social media, one has to be very, very cautious. Anything on social media is out to the public, and that can be viewed by the CBP officer. Sometimes even if you keep things private on the social media website, maybe when you're entering the country, the phone can be seized from you and the officer can inspect the phone. So even if you keep things, some messages in private mode, the officer might be able to look at them, inspect while he's looking at your phone. Okay, so again, yeah, yes, the CPP officers can do that. Again, national security is of utmost importance. Making sure that people are following rules is of utmost importance. And because of these reasons, yes, those officers, the government officers, are doing their job, and they do have the right to do those kinds of stuff.
Okay, but what about privacy? I mean, photos or anything that are very, very private. What about stuff like that? I mean, you
Sure.
said
And
we can
again,
actually inspect, right? Yeah. Sorry.
yeah.
Go on, Chan.
So again, yeah. So again, in US, privacy is a very important concept. So if somebody is sitting in United States, somebody is who's on a non-immigrant visa, and they have a phone,
Mhm.
officer cannot just come into their home and say, "I want to take your phone and inspect your phone." They cannot do that because it's right to privacy. So in US, what happens is if you're inside the border, inside the US border,
Mhm.
to do anything of that sort, to seize your phone or seize your personal belongings and inspect, the officers would need a warrant. So unless you get a warrant, you cannot really inspect anything. You cannot really inspect the phone. But that rule is if you're inside the US border. And for this is the general rule. And what happens at the airport is at the airport there is something called a border exception. So what that means is if somebody has just got out of the flight, they're entering United States, they have to go through a CBP inspection. So until the inspection is done, the CBP officer admits somebody into United States. They're not really inside United States. So technically, until that point of time, there is a border exception. So without a warrant, the CBP officer can take the phone and can inspect the phone. So so for general purpose, if you're inside US, you're admitted to US, yes, the officer will require a warrant. But before you're admitted to United States, so at the CBP, you've not yet been inspected, you've not yet been admitted to United States. So at that point of time, using this border exception, the officer can inspect the phone without a warrant. But usually, once you're inside the country, they always need a warrant. They have to go through the process, and getting a warrant, all those things have to be followed.
Okay. Great. Thank you, Chan, for making it very clear for us. And I hope, Akhil, you got your answer to your question as well. Thank you for your question. And, I think we should just go for a short break. But before that, should we take up another one from Raza Design? Raza is asking H-1B 2022 audit case. What What are the consequences that application is in USCIS audit? And how much time is required to get an audit response from USCIS?
Um, so again, depending on the kind of audit, some cases could take some time. And that being said, again, when you say an audit, my guess is the case is still under process. So if the case is under process for a very, very long time, more than likely it is going through some kind of audit, some kind of a additional background checks, and the case is getting delayed. Normally what somebody should do is at a certain point you should probably try to upgrade your case into premium process. So when you upgrade the case into premium processing case, USAS typically will at least issue an RFE and will at least tell you the reason why it is getting delayed. But if not, again, if the time has not elapsed, it is within the timeline, I think give them some time. But if you think, I mean, in your case, you said it's a 2022 case, so it has been a very, very long time. I think the first thing you should do is have your attorney create a service ticket. That's the first thing I think they should do. Create a service ticket and see what kind of a response you get from USCIS. USCIS typically within 30 days they will come back and say either it is under active review requiring some additional checks, or they'll tell you something. That is the first thing you should do. And after that, if you're still not getting a response, I think the next best course of action is upgrade your case, put it in premium processing. If there is an issue, they will at least issue a notice and tell you what is going on, what is wrong. At least that way you can speed up the process.
Okay, thank you so much for answering that for Raza. Thank you, Raza. Well, I think we should just go for a short break now. And folks out there, don't go anywhere because we will be right back after a short break with more insights on discussion of immigration laws and visa matters that we are discussing today, especially RFEs. And yes, as also, so you can contact Chand, you can email him and contact him at chand@spblawfirm.com, and you can also visit his website, spblawfirm.com, and call him in the number 817-523-8247. And yes, don't go anywhere. This is Nipasa Pradhan on Immigration and Jobs Talk Show with Chand Parvathaneni.
You an IT consultant seeking a new opportunity? We offer job placement services for US citizens, green cards, EADs, and visa holders. We also sponsor various work visas like H-1B, E3, TN, and green cards. 20 plus years of experience in the industry. Exceptional employee benefits. Highly rated by our employees. Global presence with 200 plus recruiters and direct clients. Connect with us. Call us in the number 408 335 6444 or mail us at nipa@higheritpeople.com or visit our website www.higheritpeople.com.
Hello and welcome back, everyone, to Immigration and Jobs Talk Show. I am Nipasa Pradhan, and today we have with us Chnge Parvathaneni. He is an expert immigration attorney from Dallas, Texas. SPB law firm is his law firm, and thank you so much, Chnge, for joining us today. And folks out there, today we are discussing about H-1B RFE trends and also about consular process versus change of status for H-1B. So if you have any questions under this topic, have any doubts, don't forget to comment. We will be happy to take up your questions and answer them for you, make them more clear for you. So Chnge, let's move on to another question I have for you. And that is, should one consolidate all documents into one PDF for online submission to USCIS? Also, if the person has compiled travel and lodging documents, do they need to also include bank transaction details?
Sure. So I think if one is talking about online submission for RFEs at this stage, more than likely they're talking about OPT RFE because a lot of students file for I-765 online, they get an RFE. And so I think the question you asked, whether one PDF for online submission is a good idea, I think it's definitely a good idea. That's how we do it. We try to consolidate everything into one single PDF. The only thing is make sure you put the table of contents on the very top. And for whatever contents you have, try to put an exhibit. So that way you're able to kind of differentiate when one section ends and the other section starts. Definitely do it as one single PDF, consolidate everything into a single PDF, put a nice table of contents, ensure that you're providing each and every document that USCIS is asking in that RFE. And the consolidated PDF should be good enough.
And what about bank transaction details?
Again, this is a recent trend. So what we are seeing is recently USCIS, first of all, the trend for the 765s, the EAD cards. We are
Mhm.
seeing an increased trend in the RFEs. We are seeing more and more RFEs for EAD, OPT EAD cards. And one common question that we see is regarding the bank transactions. And when they ask for the bank transactions, I think you should include the bank transactions if you are asked by USCIS. If you're not asked, you do not have to include it. But if you're asked for bank statements, I would definitely, you should include it. But again, if you're just trying to provide the bank transactions to show your travel and lodging, I would rather show it with maybe the invoices, the receipts. They're probably easier. But again, transactions, if you're asked to provide, you do need to provide it. The only thing is when you're providing bank transactions and you have some weird monetary transactions, some cash transactions, you should at least explain it to USCIS. Don't give them a chance to kind of cause a problem. Be proactive, and while you include your bank transactions, give an explanation. Because I think what they're trying to do is, if they see some kind of erratic monetary transactions, the first thing that would get to anybody's mind is this person working without authorization? Is he getting paid under the table? So all those kinds of things would happen. So if you ever see some kind of transactions that don't make sense, do at least provide an explanation. So again, some RFEs are specifically stating that bank transactions for a certain number of months have to be included. And if your RFE is one of those RFEs, do provide the bank transactions, but provide an explanation on any kind of weird transactions that you see in your specific case.
Okay. Okay. Thank you so much, Sean, for taking that up. And, let's take up some viewer questions. Let's take up this one from Shivranjan. How to prevent RFEs on H-1B? Any tips? I think we just, yeah, Chand, please.
Yeah. Sure. So you can do a couple of things to prevent RFEs. That being said, I mean, I've seen it a number of times where when everything is good, the same company doesn't get an RFE like for 3 or 4 cases. Then all of a sudden, that same company gets an RFE for something that talks about show we are not able to find information about your company. Provide us all these details. When 3 or 4 other cases the same month which got approved did not get that RFE. So what that means is yes, you can take some preventive measures, but they're not 100% foolproof because it also depends on the officer that is looking at your case and the kind of the issue that that officer is focusing on. So high level, you should always be very clear about your job description. Okay, and again, that is something what the company will do. So the company has to explain your job duties in a very clear fashion. That is very important. And your own it code should be an appropriate own it code. So that is where that would prevent a lot of RFEs. So the first thing a lot of companies do is ensure the own it code is right, ensure the wage level. Because if somebody is trying to give a wage of $60,000, for example, for a software developer, my gut feeling is USCIS is definitely going to raise that issue unless there is some very good reason. Maybe it's a junior level position. So sometimes it is just a trigger because if you do things that are not normal in the industry, USCIS officer is bound to question you on that aspect. So the job duties, the own it code, I think are the most primary critical things of an H-1B petition, and that is where the first uh, focus should be. So as a company, they're first targeting the position. Ensure the right specialty occupation position is being offered, the right wage, not a very low wage. If you try to use this H-1B program to lower the wages, USCIS is going to catch you right there. So they are very particular about companies that pay low wages. So that low salary wage levels is very important. So somebody has to really analyze to ensure that somebody is not getting underpaid. That is very important. The right own it code is being used, not simply an own it code to just drive down the wages. So those are the kind of things that would make the case strong upfront. And after that, the next thing to prevent RFS is to clearly show the beneficiary qualifications. If somebody has a computer science degree from US, you don't really have to do anything. That is enough. But if somebody does not have a degree from US, they just have a bachelor's degree in computer science from India, you might have to get an evaluation done. If somebody has a non-computer science degree, then maybe you have to club experience, do a work experience and education evaluation upfront. That will again prevent an RFE. And also look at your current status. If somebody is in US on F1 status, make sure you prove that you're in a valid status. What that means is, if you're doing CPT, if you're on F1, all your I-20s should clearly show the changes. For example, the employment changes and so on. And so, uh, show evidence about your current status. So there are a couple of things. Definitely, I think target the beneficiary qualifications, basically employee qualifications. Target the position qualifications. So very clear explanation about the position. Target your current status. If you do these three, majority of the time your RFE chances are minimized. That being said, sometimes no matter what you do, you get an RFE, but it will be a simple RFE sometimes.
Okay. Okay, thank you. Thank you for taking that up. And Shivaranjan, I hope that was clear for you today. And let's move on. We have another one. This one is on YouTube from CV. CV is asking, I am F1 student, will be graduating by December 2024. My H-1B was picked. Can I complete my graduation and work on H-1B from Jan 2025?
Sure. So again, so there are two ways to handle this. One, you can change to H1, and once you change to H1, while you're working, you might be able to complete your studies. That is one way. There is also another way. So this year, USCIS also came out with this other announcement, and what that means is, normally for the CAP filings, October 1st should be the start date. This year, USCIS said that October 1st does not have to be the start date. You can delay the start date. So you can delay the start date a little bit, and there are rules. So in your case, what you should do is talk to your company, talk to your lawyer, if your company has a lawyer, talk to them about delaying your start date. they can delay the start date, and that start date does not have to be October 1st. So you might be able to use that feature where the start date does not really have to be October 1st. That is one way. There is also another way. The other way is if your company files it as consular processing, you finish your studies, you go to India, get stamping, and then come back. Okay, so there are various ways. One, you can just file it as consular processing. Second, you can just delay the start date. And third, maybe you start working on H1 and finish your graduation while you're studying. You can enroll in college, you can enroll in studies while you're on H1. When you're on H1, the rule is you have to work for that employer. So as long as you're working for that employer under the terms of that petition, if you're additionally going to college and getting education, that should not be a problem.
Okay, CV, all the best for your exams. I hope you, uh, fare well with flying colors for sure. And here's already wishing you the very best. I hope you also get to join the job you're looking for. All right, so Chand, Shiva has a follow-up, so let's take that up quickly before we move on to another question. Shiva's saying H-1B RFE specialty occupation for this, what documents or information do we have to send to the USCIS? Is this only project or role related?
So if it is a specialty occupation RFE, what USCIS is arguing is they're asking us to prove that this particular job, the job duties, they really require a bachelor's degree in a very specific field. So, for example, they issue an RFE for, say, one position. So, as a company, the company has to prove that that particular job title, those particular job duties do require
Mhm.
somebody with a specific degree. For example, if the company claims that, hey, we require a degree in computer science, because that's a
Mhm.
specific degree. The first thing is to prove that you require a specific degree. So that is number one. And the next thing is to do these job duties. You really require somebody with such kind of a education. The way you prove it is you will require detailed job description. So you definitely will have to expand whatever duties you have given to USCIS in the past, explain and expand it a little bit more, clarify through percentages, how much percentage of time you're allocating to each and every job duty. Because each and every job duty should be a technical job duty. You cannot spend time in doing marketing if you're supposed to work as a software developer. You're supposed to work as a software developer means your 100% of time should be focused on those particular job duties. So expand the job duties, uh, notify USAs about the percentages. And additionally, there are a couple more things. So there are various ways in which you can prove a job is specialty occupation job. You have to prove that the job is very complex, and it is so complex that it can be done only by somebody that has theoretical knowledge of that particular field. What that means is
Okay.
expand your job description, show how complex your job is. That's one. The other way is we also get expert opinions. Very commonly, we go to a professor, we ask the professor to evaluate your job description, ask the professor to give an opinion. The professor's opinion is very important because if the professor feels that this job is a complex job which requires a bachelor's degree or a higher degree, that is one way. There is another way. The other way is look at the industry standards, show the occupational outlook handbook reports, show the Bureau of Labor Statistics, BLS reports, ONET reports, show that yes, this occupation by default on an entry level requires a bachelor's degree. So you'll be able to find all those documents online. And another way is look at what your similarly situated companies are doing for those job duties. If similarly situated companies are also hiring with at least a minimum of a bachelor's degree, find their evidences. Go to some job sites, find some evidences. You can also use that to prove that your job is a specialty occupation job. So there are a number of ways. So what you're targeting is you're collecting all this evidence to prove your job is complex. You're also providing all this external evidence, maybe professor expert opinions, these job postings from other companies, and all these various ways to prove that this job requires a specific degree in a specific field. Doing so, you target your specialty occupation RFE.
Okay. Thank you so much. And Shiva, thank you for that question. I hope that was clear for you. Well, thank you so much. Also, Sev just messaged me in my number, which is displayed on the screen. He's asking, hey, Nipasa, my F1 visa interview is in June. I need to take the perfect preparation for that. Can you help me out with this?
Sure. So when you're going for F1 interview, F1 interview is a little different from H1 interview. So for F1 interview, There are two things that the officer is very, very concerned about. One, are you really going to study in a US college? Do you have the funds for it? That is number one. So their whole goal is, if you're going to go to study in some university, are you really going to study? Basically, do you have the funds? Because if you don't have the funds, you can't really go and study. So they're really focused on, do you really have the funds to go and study in that college? So they're going to focus a lot on that part. And the next most important part is, you're going there to study. You should have a single intent. The single intent is, you're not going there to stay back in US forever. You're going there to study. And what that means is, the officer has, by the current regulations, it is their job to make sure that you actually study, and once you finish your studies, you're actually coming back to your home country. So they want to make sure you have strong ties to your home country. So they want to make sure that your intention is to actually finish studies and go back to your home country. So the questions they ask you will revolve around what kind of ties you have to the home country. Do you have property in India, if India is your country? Do you have uh, a family, property, family? And what kind of motivation you have to go back to India? So these are all the kind of things they see to judge that your intention is to go back to home country. So pretty much what that means is, you have to convince the officer of two things. Yes, you have the funds. How are you getting the funds? Who is funding you? And all those things. You have the funds to be able to successfully complete your F1 studies. They don't want you to work part-time illegally and earn money, which is why it is super important that you demonstrate all your funds and how you're able to finance your study. Very important. So your interview is going to be a lot of those kind of questions. The second is, why do you intend to go back to your home country after your studies? So basically talk about your ties and all those things. So be prepared on all those questions that target these two aspects, and then your F1 interview should be pretty smooth. And looking at recent trends, what we are seeing is F1 visas are being issued relatively easily. But again, every officer will definitely check these two things that I just told you about.
Okay. Okay. Thank you so much for enlightening us. And Saif, I hope that was helpful. Thank you for messaging me on my number, which is displayed on the screen, 408-335-6444. Very easy number. And you can even email me, friends, if you have direct questions, nipa@higheritpeople.com. We even help out with project placements if you're looking for one, green cards, TN, anything visa related. Don't forget to reach out to us. All right, so let's move on. There are more questions. I think we should just jump into the questions quickly. Let's take this up from Pavan. Pavan is asking, got an H-1B RFE on my education, and I don't have education evaluation for my Indian masters in mechanical and have 4 years of experience in IT field. Please suggest, what do I need to do?
So in your case, mechanical degree is not a valid degree. But that being said, you said you have 4 years of experience. Normally, our experience is, if you have 3 years or more, in your case, you definitely have that experience. All your company simply has to do is, they have to document your experience, take those experience letters, take your education, do a combined evaluation. And the way they do it is, they will have to approach a professor, a college professor in US from an accredited university, and they have to get your evaluation done. And we have a lot of these kind of cases where somebody has a mechanical degree, but they are qualified because of experience. So we simply have to get a work experience evaluation done. So more than likely, my guess is your company already asked you to provide those work experience letters. And what the company will do is, once they get them back on their side, they will provide it to a professor. They will get a combined work experience evaluation done, and they will use that evaluation, that expert report, to answer your RFE. And since you said 4 years, my guess is they will be able to provide an equivalency for you in the relevant field when they use your experience, and more than likely you should be okay for your RFE.
Okay. All the best, Pavan. I hope you can figure out. Thank you so much, Chan, for helping out Pavan on this. Let's move on to Mithilesh. Mithilesh is asking, what are the key differences between the consular process and change of status for H-1B visa holders, and which one is more advantageous in current circumstances?
Sure. Actually, it's a very good question, and it's a part of our topic today. And
Right.
so when somebody is in US on any status, for example, on F1, on H4, on L1, L2, and they're trying to convert to H1. There are two ways. Okay, a lot of people don't know this, but there are two ways in which you can get your H1B. One is through consular process, and one is through change of status. And what is the difference? So when somebody files H1 with change of status, for example, they put a start date of October 1st, and they say we are filing it as change of status. What that means is the minute the case gets approved from October 1st, you are supposed to be employed and you are supposed to work as per the terms of the petition. So what that means is uh, you have to ensure that the minute your case gets approved, from the date the change of status is effective, it will be on your approval. It will say the change of status is approved. This is the date. So from that date, you are supposed to work for that employer. You're supposed to get paid by that employer. You're supposed to only do those job duties that that particular approval requires you. So this is what change of status means. Change of status means whatever your current status is. If your current status is, for example, F1 OPT, that status will terminate. If your status is L1 and you're working for, say, TCS on L1, that status will terminate. And what that means is you're supposed to stop that and start working for the H1B company. That is what change of status means. And the other side, the consular process. Consular process means, for example, your company applies for you under consular processing. So what that means is the day you get your approval, the H1B is approved, but because your change of status is not approved, it is consular processing, you don't really have to start working for that company. So for example, you are on L1 visa working for TCS, and you get a approval with consular process. So what that means is from October 1st, you don't really have to work for the H1B petitioner. You can continue to work for that other company because your other status is still valid. Before you go, before you join this company, there is an extra step. You have to go and get visa stamping. That is pretty much the problem. The problem is, yes, you got an approval, but you don't really can start that employment until you go and get your visa stamping. But why is it still advantageous? The reason why some people use consular processing is because some people are on L1 visa, for example. They want to continue to work for that employer for some more time and then start the H1B. So they might see consular processing as more advantageous. And also some people on OPT. So a lot of people on OPT still have 2 years, 2.5 years left out on their EAD cards, for example. Their STEM OPT has not even started yet. So those people on EAD card, they have a lot more flexibility. When they're changing project, for example, under H1, if you change a project, you have to file an amendment. You don't have a choice. By rule, you're supposed to file an amendment to be in compliance. You're supposed to maintain everything that the petition requires you to do. On OPT card, you have more flexibility. So a lot of people like that flexibility. So people want to maintain their F1 status for a couple more months. So for somebody who has 2 more years of OPT, if they want to keep continuing their OPT, so again, consular processing is probably attractive for those kind of folks. So what happens is they continue their OPT, they get an H1B approval. At some point down the line, they will probably go for visa stamping, or sometime down the line, they will get converted back to H1B status. Okay, so there are again advantages in change of status. There are advantages in consular. It depends on what your case is. The thing is, if you want to start working for the H1B company on H1B status right from the day of approval, from October 1st, change of status is what I would recommend. But if you have other status and you want to maintain the other status for certain a couple more months, maybe like the OPT or maybe the L1, then definitely consider consular processing. Both are valid. In my opinion, consular processing is a little bit easier. The reason is, for the change of status, you have a burden to prove your current status. For consular processing, because you're going for stamping, you don't really have to prove your current status. So things are a little bit easier from a I-94, from a change of status perspective. But the underlying H-1B, the burden of proof is exactly the same. You still have to prove you're qualified. You still have to prove the company is legitimate. So those things don't change. So those things are still exactly the same. The whole reason why people use this or that is because they want to delay their H-1B start date. They want to continue their current status, delay their H-1B start date. That is when you would consider consular processing.
Okay. Thank you, Chan, for that. And we have a follow-up question. We should take that up. This one is from Amzad. Amzad is asking, my H-1B got picked up in this year's lottery. I spoke to the HR and they will be filing the petition now on regular processing due to budget constraints on due to budget constraints on premium processing. Oh, regular processing because of budget constraints. Yes. So there's a follow-up. Can an employee pay for the premium processing fee for the petition? I just want it for the peace of mind to expedite in case of RFE.
Again, a good question. Employee cannot pay any H-1B fees except premium processing fee. So the premium processing fee is the only fee you're allowed to pay. Anything else should be employer's responsibility. The premium processing fee, yes, you can pay. That being said, let me tell you one thing. The premium processing is $2,805 for H-1B. That being said, we are seeing cases getting approved very soon. When I say very soon, I would say 2 to 3 months is pretty much what we are seeing nowadays. Again, for most of the cases, not for all cases. So again, if you can wait for 2 or 3 months, maybe ask them to file it in regular initially. Down the line, in 1 2 months, if you're not getting an approval, upgrade it down the line. But again, if you absolutely want peace of mind, go with premium. It is not required because nowadays USCIS is very quickly processing cases. They have become very, very fast. And not only on H-1B, we are seeing pretty much a lot of other cases also getting faster adjudications. So again, I mean, I would not be surprised if I see your case getting adjudicated in a 1 month to 2 month time frame. And again, if your company files a case in the month of April, more than likely it will be a lot more faster because not many people file in the month of April. As it gets to June, more and more people are trying to beat the deadline, the June 30th deadline. Things will be slower. So if your company is willing to file in the month of April, I think you should probably go without premium because I've seen a lot of cases get approved very quickly, and you might even get an. I mean, I've seen cases get approved faster than premium processing cases last year. Cases that got filed very early in the beginning. So again, it is up to you. You do have a choice. You can pay. The company doesn't have to pay premium processing fees. You can pay for it. That being said, cases are getting approved very quickly.
Okay, but he says that he is having some budget constraints, so probably he would want the company to pay. So what do you suggest, Chan?
No, no. I think he means the company is having budget constraints, so they're making him pay.
Oh,
So
oh,
because the
okay.
yeah,
All
so
right.
which is legal. Yeah, that is legal. Yeah.
Okay, okay. So
So because
Amzad,
the
I
company
hope
is
that
not
is
able to
clear
pay.
for you. Okay, okay. All right. So thank you so much, Chan. So yeah, cool. I think you can go ahead then. Let's take up this next question. This one is okay. Shiva Ranjan also has a follow-up. Out of the box question. Can you please tell me the current green card perm process time?
Sure,
Do you want to
it's
take that up?
absolutely horrible right from the yeah. So the processing time is extremely horrible, and this is the slowest I've seen in my legal career as far as the perm processing is concerned. So to do the perm processing, you initially require prevailing wage. The prevailing wage is taking about 6 months of time right now. Once you file the perm is taking at least 12 to 13 months. So right now, whatever was filed in last March, those cases are getting processed right now, the perm application, the perm labor. So the labor is taking about 12 to 13 months, prevailing wage about 6 months. So you're looking at least a year and a half. If you start the process today, by the time you get your labor, it is taking about a year and a half. And this is like very slow. But again, things are very bad on the perm processing time. Once the perm is done, I-140. I-140 can be done pretty quickly. You have premium processing. So I-140, you can do it very, very quickly. So in less than a month, you can expect I-140 approvals. After that part, you have to wait for your priority date to be current. The priority date right now, it's in 2012 for India, EB2, EB3. We are in 2024. And I don't anticipate priority date moving very quickly in the next couple of years. If rules change, it's a different issue. With the rules being as they are right now, the priority date is very, very bad. So 2024, if somebody applies their initial perm, we can expect a long time, a couple of decades before the dates become current. That being said, if the rules change, things could get better. But in the existing rules, things are extremely bad if you have a current priority date.
Okay. Okay. Thank you so much for answering that, Chand. Well, before we move ahead to another viewer question, I also wanted to ask, what steps can be taken if someone has been waiting for 11 months after receiving a 22(1G yellow slip during visa processing and it shows refused? But of course, tell us what is a yellow slip first.
Sure. So the Department of State, the consulate, they typically give various slips. So 221G is not a denial. So the first thing everybody should understand is a 221G is just a refusal. So what the consulate, the Department of State, is stating is they need some other additional steps to be done, and they're refusing the visa at the current time, and they're keeping it in pending state. So it's just a refusal. It's not a denial, and they give various colored slips. So there is a white slip, there is a blue slip, there is a pink slip, and there's a yellow slip. These are the four common colors that I normally see. And yellow slip is typically saying uh, we need some more time to process your case. That's pretty much what a yellow slip says, typically means. And that being said, in this case, if somebody's case is in that refusal for more than 11 months, it is probably it's taking a long time. So 11 months is kind of abnormal. It's definitely not the norm. It's abnormal. That being said, I do see a couple of cases for some reason they're not able to complete all their background checks, so it exceeds the timelines. So normally there are a couple of things you can do. 11 months, definitely at 11 months time, somebody should be contacting the embassy a couple of times a month. The reason is somebody should be reaching out to the consulate and saying, okay, is there anything else I can provide you to expedite my case? Sometimes you get a response, sometimes you get the same standard, the boilerplate kind of a response. But again, the first thing is do contact the consulate. And if you're not getting any response back from the consulate, normally there are two other things that you can do. They're not easy. One, if you have an attorney, the attorney can use something called LegalNet. So take LegalNet's help to route a request through them to the consulate. That is one way. But again, that is not easy. So you definitely LegalNet requires an attorney to be involved. But again, it is not a guaranteed process, but it is one of the things that people can do. The next thing that people can do is think about a lawsuit. You might be able to file a lawsuit, but again, a lawsuit is not a guaranteed thing to succeed, especially with the consulates, especially with Department of State. But again, a lawsuit is one option that people have started using, and some people say they're successful. I've talked to many attorneys. Some attorneys feel that it is uh, not successful all the time. Some attorneys feel that they don't know if it is the lawsuit or it is just that the time was over and that the case got approved. There are mixed opinions about a lawsuit, but again, in terms of recourse, a lawsuit is one thing that you can consider. And I'm very, very clear that lawsuit is definitely not something that would guarantee you success. And my experience is I've not seen a lawsuit causing an approval. That being said, when you have a lawsuit, at least what happens is people tend to take this case seriously, and if there is no issue, at least they might tend to issue the visa. The problem with the lawsuit is if the case is denied for a reason, and the courts typically have limited options. The courts typically, if it is denied because of a reason, the courts typically will not interfere. But a lawsuit is an option, and many people are using that route. So something to think about. Again, every case is different. So in your case, you do might want to explore the options of a lawsuit if everything else fails. And when I say everything else, the first thing is contact the embassy a couple of times. Try to involve LegalNet if possible through your attorney. If those two fail, maybe as a last resort, at least do some research on initiating a lawsuit.
Okay. Thank you so much, Chan, for clearing that out for us. And yes, I also got another message. Thank you so much on WhatsApp. It's anonymous because I cannot catch his name yet. But he's asking, "Hi, I got fully funded PhD position and have gold medals both in my bachelor and master's degree. Additionally, I have 4 publications. My kid is very small, so I need to take my family with me as well. I don't have any other option. So I am very afraid as I see a lot of rejections, even for PhD positions for my country. Please give a good advice, which will help me in passing the interview." We showed 1.5 times in our I-20 required funding. Husband will use his F2 visa to visit us for 2 to 3 times in a year.
Yeah, and again, unfortunately, I think some countries do have more denials. And again, the PhD program, again, if it's like a chemical engineering program, a biomedical program, I do see more scrutiny. Computer science, I see less scrutiny in general. So again, USCIS, Department of State, so all these governmental bodies, so they have different triggers. And in your case, I see that you have a fully funded PhD position. So my guess is you're trying to get a F1 visa for a PhD. So the fact that you have a funded PhD position, your case is very strong. There is a reason why you got the funded position. It means that you're valuable. You will be able to provide some additional help to this university. So the very fact that your record is very good, you have gold medals in your bachelor's degree and master's degree, you got a funded PhD position. The minute you have scholarship, the minute you have funding for your PhD, your case typically, in general, your case, you have a very strong case. So what that means is, even though your country might have more rejections, at least your case is one of the strong, very very strong cases. That being said, depending on the kind of a PhD program, if you're coming for a biomedical program, if you're coming for a physics program, so those kind of programs, I always see challenges. The reason is there is a lot of vetting that needs to happen for some kind of programs, because maybe because for various reasons. When you see things that can be misused, like biomedical, like physics, those kind of things, the scrutiny becomes a lot more. So sometimes, depending on your, because I don't know your PhD, the major, uh, but again, you might have more scrutiny. That being said, if it is a fully funded position, that means you're a very valuable person. Your talent is required for US. Otherwise, the university will not give you funding. So that's your strength, definitely. So I think your case is strong. But again, there are two things that you will need to prove. You do have the resources to continue your program, F1 program, which you clearly do because it is a funded position. So the very fact that your I-20 will show the funds available from the school, the scholarship, your case becomes very strong. Part one. The part two is they want to make sure that you have strong ties to your country. You will come back to your country. So irrespective of everything else, for an F1 program and for also your dependents who are going to come on F2, they want to make sure that they will come back to the country. And in your case, you said that your husband, he needs to come visit you, and he also needs to go back to the home country because he has probably other things, maybe his job or his business and so on. So that is actually good because you show those ties to the home country. And by showing ties to the home country, your husband will be able to prove that, yes, he does need to come back and he's not going to immigrate permanently in the United States. So I think overall, I think your case is strong, and you just have to go and give it a shot. Definitely focus more on your funding, focus more on your publications, because that will clearly show that you are a very meritorious student, and you are the kind of person that US universities require because you already have previous history of publications. And with that kind of a history, you're definitely going to contribute more to the science and research in the country. Highlight those. I think your case is definitely strong with that funding that you have mentioned.
Mhm, mhm. Okay, I wish I knew the name, it's anonymous. I've asked for the name. I hope you're tuned in. I hope you got your answer. But would definitely thank you so much, for the question, and thank you, Chan, for taking that up. And I think with this, we would wrap up our session for today. Thank you so much, Chan, for patiently answering each one of them. And you can always directly mail Chand your questions as well, law@spblawfirm.com. You can even visit his website, spblawfirm.com, or call him in the number 817-523-8247. And thank you so much, Chand. I hope to see you in the next week because there are many more questions. I think we can cover that in the coming week, or maybe dive into another topic as well. Let's see. All right. Thank you, Chand. Have a great day ahead.
Thank you, Nipasa, and thank you all watching all over the world.
Yes, in fact, Shiva Ranjan says thanks, and even Pavan says thank you, Chand and Nipasa. Thank you, Pavan. Thank you, CV Reddy, because you answered the question. So, yes, thank you so much, each one of you, for tuning in and for your questions as well. Keep on commenting your questions even after the live stream is over. We are going to be very happy to take them up. You can even mail me directly or call me in the number 408-335-6444, or just drop in your mail to my email address, that is at nipa@higheritpeople.com. And friends out there, also visit our website, www.higheritpeople.com. This is Immigration and Jobs Talk Show. Please don't forget to subscribe, because we have very, very engaging and enlightening sessions like these. So thank you so much, everyone, for tuning in. This is it for today. Have a great day ahead. Signing off for now.
Thank you.
Are you an IT consultant seeking a new opportunity? We offer job placement services for US citizens, green cards, EADs, and visa holders. We also sponsor various work visas like H-1B, E3, TN, and green cards. 20 plus years of experience in the industry. Exceptional employee benefits. Highly rated by our employees. Global presence with 200 plus recruiters and direct clients. Connect with us. Call us in the number 408-335-6444 or mail us at nipa@higheritpeople.com or visit our website www.higheritpeople.com.